Welcome to the Office of Spill Prevention and Response's recording of public comments taken on proposed regulatory changes to the drills and exercise requirements for oil spill contingency plans. This hearing was conducted on July 11th, 2013 in Sausalito, California. I'm Mark Newberger, Regulations Analyst representing the Department of Fish and Wildlife's Office of Spill Prevention and Response. It is 10:03 a.m. on Thursday, July 11th, 2013, and we are gathered here today in Sausalito, California to receive public comments on a proposed rulemaking action by the Office of Spill Prevention and Response. The office has proposed the amendment of regulations governing drills and exercise requirements for oil spill contingency plans. These regulations specifically relate to Title 14, California Code of Regulations, Section 820.01, and Forms CDFW 1964, CDFW 1965, and CDFW 1967. Under the rulemaking provisions of the California Administrative Procedures Act, this is the time and place set for presentation of oral or written statements for or against the proposed regulations. Notice of this hearing has been both published in the California Regulatory Notice Register and sent by mail to interested parties. This is a quasi-legal hearing in which the office carries out the rulemaking function delegated to it by the state legislature. Witnesses presenting testimony at this hearing will not be sworn, nor will engage in cross-examination of witnesses. We will take under submission all written and oral statements presented during this hearing. We will respond to these comments in writing in the final statement of reasons. This entire APA rulemaking hearing will be recorded. The transcript of this hearing and all exhibits and evidence presented during the hearing will be made part of the rulemaking record. The record for this hearing is being kept open until 5 p.m. on July 11th, 2013, in order to receive additional written comments from interested parties. If you have both written comments with you to submit during the hearing today, please give a copy to me. We have a sign-in sheet available which asks for your name, business affiliation, and address, telephone number, and whether or not you wish to submit written and or present oral comments. Please fill out this sheet even if you do not wish to speak or submit written comments today. If you fill this out and provide your complete address, we will notify you before final adoption of any changes to this proposal or about any new material relied upon in proposing these regulations. Such a notice will be sent, 1, to everyone who submits written comments during the written comment period, including those written comments submitted today. 2, to everyone who testifies today. And 3, to everyone who asks for such a notification. While no one may be excluded from participation in these proceedings for failure to identify themselves, the names and addresses on the sign-in sheet will be used to provide the notice. If you have not yet signed in and wish to do so, please let me know now. We will take oral presentations on each regulatory section sequentially. After we hear from everyone who has filled out the form, we will hear any latecomers or anyone else who wishes to be heard. When it's your turn to speak, we ask you to do certain things so that the audience can hear you and so that your comments are entered into the record. We ask you that you come to this microphone right here, when you are called to speak. Please begin by stating your name and identify the organization you represent, if any, and tell us the section number of the particular regulation you want to discuss. At this point, the rulemaking record consists of the office's notices package, which includes the notice of proposed action as it was published in the California Regulatory Notice Register on May 17, 2013, the initial statement of reasons, and the full text of the regulations. These regulations were duly noticed more than 45 days prior to today's hearing. Copies of the notice, together with the regulations and initial statement of reasons, were mailed to all interested parties who have requested rulemaking notices. We will now take oral comments on the proposed regulations. In the interest of time, if you agree with the comments made by the prior speaker, simply state that fact and add any new information you feel is pertinent to this issue. Can I have the first speaker?
Good morning. My name is Amy Trainer. I'm the Executive Director of the Environmental Action Committee of West Marin, and I am here to comment on Section 820.01. I appreciate OSPR giving the public the opportunity to comment on the proposed rulemaking. And the Environmental Action Committee submitted our written comments already, but wanted to highlight on a few important points. Our comments are made in an attempt to strengthen the prevention capability to keep spilled oil out of the marine waters of our state, and to remove spilled oil using mechanical containment using the best available technology as required by the Limpert-Keene Sea Strand Oil Spill Prevention and Response Act. The Environmental Action Committee firmly believes that the application of chemical dispersants to oil spills in California marine waters is not best available technology, and that chemical dispersant efficacy in cold water is a myth. California's own tests prove that effective dispersal rate is only 16% for Corexit 9500 and 22% for Corexit 9527, which falls far below the EPA's 45% required efficacy standard. More importantly, 7 different companies are currently offering mechanical equipment capable of achieving more than 70% oil recovery efficiency. These highly efficient disc skimmers are but one piece of best available technology lacking in the state's toolbox of prevention and response assets. Thus, the Environmental Action Committee's comments reflect the necessity for California to remove dispersants from the list of options available for oil spill response, develop a long overdue world-class prevention program, and greatly enhance the training, equipment, and mechanical recovery and removal requirements for oil spill organizations to come into compliance with the best available technology standard. So overall, we believe that the practical impact of OSPR's proposed rulemaking amendments in Section 820.01 at this time would be to lessen the quantity and quality of state-required announced and unannounced equipment deployment exercises. Given that the state is already in serious non-compliance with the best available technology standard as required by the Limpert-Keene Sea Strand Act, this loosening of requirements is not justified, and we have seen nothing presented by OSPR to justify the loosening of these standards. Thank you.
Did you put your information on the sign sheet?
Mm-hmm. And I've emailed it to Yvonne as well as to Joy.
Okay. Next week.
Good morning. My name is Chris Jones, and I am a Maritime Operations Consultant for the Environmental Action Committee of West Marin, and I agree with the previous speaker's comments and would like to provide my own comments herein. The Environmental Action Committee believes that the cost listed for the proposed exercise, $70,000 to $125,000, is not accurate and is too large. What do these figures include? Please explain how OSPR arrived at these figures. These comments are regarding Section 820.01, drill and exercise requirements. In addition, we do not agree with the following statement. Many, if not most, vessel plan holders already do large exercises in California that would meet the requirements of these regulation amendments. Is there documentation to support this claim? Is there documentation and evidence to support the implication that a large exercise in Southern California prepares spill response organizations in Northern California for an adequate response? We believe that such evidence does not exist. There is no addition of a required unannounced equipment deployment drill program. There is only a statement that the administrator, quote, may call a drill or exercise to validate all or part of a contingency plan, unquote. Please explain how this statement, in place of a requirement, provides protection for California marine resources. Please provide documentation of unannounced exercises seaward of the Golden Gate. Unannounced exercises should be considered as a substitute for required drills only if equipment deployment takes place in addition to exercising the spill management team and shoreline protection resources. We are unaware of any state-run announced or unannounced drills seaward of the Golden Gate, so how can the state justify a further decrease in these requirements? Please provide documentation for any announced or unannounced drills seaward of the Golden Gate and explain OSPR's reasoning for the significant lack of required preparedness training. EAC disagrees that the oil spill response organizations participating in sensitive site evaluation program should be exempt from shoreline protection drill requirements. Simply stated, what you don't drill, you don't have in a response. The OSRAs need to be drilled and exercised independently outside the realm of state-sponsored activities. To suggest otherwise further exemplifies the unacceptable failure of OSPR to require the best achievable protection to the California coast. The policy statement overview states that proposed regulations are not inconsistent or incompatible with existing state regulations. Please explain how the proposed amendments satisfy the requirements of the Lempert-Keene-Seastrand Act, since they are lessening the preparedness and readiness requirements for OSROs. To comment on shoreline protection tables, shoreline protection tables highlight why prevention is so important. The nearshore habitat will be nearly impossible to protect from the landward side. Thus, a capable emergency towing vessel with state-of-the-art salvage and spill response technology is essential as best available technology prevention equipment. Much of the Point Reyes Peninsula can only be protected from the water. Therefore, a trained on-call vessel of opportunity program is essential to the protection of this environment. OSPR should immediately initiate a vessel of opportunity program that includes training in shoreline protection, towing boom and skimmers, working with mini barges, loading and unloading equipment from response barges, and regularly scheduled emergency callouts. EAC proposes to delete entirely the language in red and amend the paragraph to add the underlined language as presented. And I will read the language as written by EAC. Oil Spill Response Organization, this is 820-01A2C. Oil Spill Response Organization field equipment deployment drills for on-water recovery and for shoreline protection shall each be conducted quarterly seaward of the Golden Gate. 2 unannounced field equipment deployment drills for on-water recovery and for shoreline protection shall be conducted annually. Shoreline protection strategies shall be exercised as described in subsection 820.01b below. Section B, shoreline protection strategies for sensitive sites. Vessel plan holders are required to exercise shoreline protection response strategies. No changes in number 1. Number 2, we request that OSROs that participate in OSPR's sensitive site strategy evaluation program may meet the shoreline protection drill requirements. We request this number 2 be removed. Section G, equipment deployment drill objectives. Equipment deployment. Equipment shall be deployed to meet the state-required 4-hour planning standard for oil recovery and storage at a minimum. Section H, drill exercise documentation. Additionally, the plan holder shall include information on any recommendations for suggested action or improvements to area contingency plans, harbor safety plans, marine facilities, and vessel plans, OSROs, federal agencies, state agencies, local agencies, training or exercise programs. These lessons learned should be incorporated into future exercises and posted on OSPR's website. This information shall be kept by the plan holder for 3 years. Section J, reconsideration and hearing procedures. This section should be deleted entirely. Please explain what new information and facts could arise after an unsuccessful drill for it to be considered a successful drill during the reconsideration procedure. If the hearing process is to present evidence why an unsuccessful drill has also been denied reconsideration should be given credit, this section should be deleted. This new section is unnecessary and does not provide the state of California with best available protection. Subsection K, in-state and out-of-state exercises. Please clarify how out-of-state exercises prepare California oil spill response organizations for response in-state. Subsection K, B, letter B, the exercise tests all of the following: the marine facility or vessel spill management team and spill response organization, deployment of the vessel or facilities response equipment, and deployment of shoreline protection. In closing, EAC believes that OSPR has and continues to be negligent in its responsibilities to provide the California coast with best available protection through best available technology. The alternatives provided herein constitute only a fraction of the changes OSPR must implement in accordance with its public trust responsibility to prevent oil from being spilled into state waters, to contain spilled oil in the least harmful and most efficient manner, and most importantly, to minimize harm to people, wildlife, and the environment in the process. Thank you for the opportunity to provide comments to help ensure that people of California and its priceless environment receive the most effective means of preventing and responding to spills. Thank you.
Thank you for comments. Okay, are there any other commenters present? Okay. Thank you for participating in this rulemaking process. Is there anyone else who wishes to speak concerning the office's regulations? Hearing no requests, I hereby close this hearing. We will continue to receive written comments until 5 p.m. July 11th, 2013 at our office at 1700 K Street, Sacramento, California. Thank you to all who have attended this hearing. We appreciate your assistance in developing and refining these regulations. Finally, if you would like to be on the office's rulemaking mailing list but are not now, please give your name and address to me. The time is now 10:18 a.m. and this hearing is formally closed.